others in opposition? Seeing and hearing none. Are there questions or comments from members of the committee?
Yes.
Senator Stone?
Thank you, Madam Chairwoman. Senator Glazer, thank you very much for bringing this back. I was one of the yes votes on AB 300 by Assemblyman Cooper. My concern, in looking at your categories, the most important concern that I have was BG, misdemeanor violation of possession of a controlled substance, namely the date rape drug. And when it was originally a felony to possess that drug, we could legally swab somebody and put it into the database, and it was rather fruitful in finding that we were solving heinous crimes that were committed by that perpetrator. And as a result of Prop 47, as we know, we couldn't do that anymore, and Assemblyman Cooper's bill failed. So, a question for the district attorneys, and the ACLU can certainly weigh in as well. There was some very fine print in Prop 47 that said if we were going to make any changes to Prop 47, it had to go back to a vote of the people. So as one that wants to follow the laws, even sometimes when I disagree with those laws, I want to ensure that we're on firm ground in allowing swabs. Because I don't believe, correct me if I'm wrong, that Prop 47 actually got into the weeds about the DNA testing. So my non-legal background perspective is that we can make these amendments, these changes, if you will. So if you could please opine on that.
I believe you're correct. There was no discussion in Prop 47 about the fact that once these crimes became misdemeanors, there would be no DNA collecting. So as far as making any changes to Prop 47 requiring a vote in front of the people, I don't believe that's necessary.
Thank you.
And if I just may address your point, Senator, to just focus on the date rape drug, I share your concern in terms of that, but I think just to focus on something that sort of has a sexual bent to it misses the point that the majority of the cases that, for example, I saw as head of the cold case unit had nothing to do with sex, that were our leads to the sex cases.
Yes.
Ironically, it was sort of the more innocuous crimes that opened the door to the gnarly stuff.
No, I appreciate learning that today, but that was the hook
Right.
for me when we heard AB.
If I could just
Senator,
clarify, so
to
the-
your-
I'm
Do you-
going to have everybody come up on both sides if we're going to have this kind of colloquy, so I don't know if the Drug Policy Alliance or anybody else wants to come.
Senator,
I
to-
just wanted to answer the legal question.
And then I'll answer it as well. Go ahead.
So
Natasha.
the DNA collection statute was itself passed by the voters. So the penal code sections that we are changing here are voter enacted initiatives, not through Proposition 47, but through another initiative. That initiative itself does allow for amendments that are consistent with the intent of that initiative. And so that is the process that we're following here.
Thank you for clarifying that.
Yeah, and to your point, Senator, neither the arguments for or against Prop 47 or the Attorney General's title and summary made reference to this collateral consequence.
Thank you. Well, I appreciate the answers, and you know, this is my personal opinion that I think that the voters were duped by Prop 47 and not looking at the content of the initiative. We have to live with it, of course, today. One of the unintended consequences is that we are not swabbing people that have committed some of these crimes that could lead to restitution, if you will, by victims by putting their perpetrators behind bars for some very serious crimes. And so I want to commend Senator Glazer for bringing this back up for us to reconsider, and I'll be supporting your bill today. And if I'm not a co-author, I would like to be a co-author if it moves out of committee today.
Okay, thank you. I don't know if there are other questions or comments.
Thank you, Madam Chair. Well, I want to thank everybody for their testimony, the author for his efforts to try to find a pathway here. There's no doubt that we can cite horrific cases where a DNA match has provided the prosecution with a tool to bring somebody to justice. And yet, I think in the face of that, it's important that some of those high-profile cases not eclipse the broader implications of what we're looking at here. And I think in some of our conversations I've had with the author, we've identified in this list, and by his own research, some that maybe have a greater correlation to crimes of violence, to person-on-person crimes. I think the committee has also identified some other misdemeanors that aren't included in this list. But I'm troubled by some of the concerns raised about methodology of the correlations in your research, Senator, based on Attorney General research. I'm not doubting that, but just that research wasn't necessarily designed to some of the questions being raised in the committee today. My comfort level would be much higher if we had some more integrity in terms of evaluation of correlations of types of criminal conduct and correlation to violence. And I know we heard from some of the proponents that you can take these swabs from a shoplifting case and potentially make a match. You know, one of our challenges is to find the balance that protects the civil liberties of the accused, as well as the rights, the needs of the victims. So for that reason, I'm struggling with this. I would be in a better position to be supportive if we had some better data that would justify crossing the line from felonies to misdemeanors. It's been pointed out that in the ballot measure it was silent about DNA swabs, but it was explicit about the will of voters converting certain felonies to misdemeanors. There's been a lot of misinformation in my community, the communities I represent, that somehow Prop 47 and these misdemeanors mean people aren't being charged, they're not being prosecuted, and it's a free pass if you are accused of one of these crimes. Well, I have learned that that is not the case. People that get it, it is within the discretion of law enforcement when and whether to arrest, and within district attorney's discretion whether to prosecute, whether to seek jail time, and that is how our criminal justice system works. It's law enforcement, it's district attorneys, and it's the courts and judges. So there's nothing in this list of what voters supported reducing from wobblers to misdemeanors that says people charged with these crimes are going to walk, and that there's no consequence to being charged with one of these crimes. There is a consequence. There can be a consequence. The question before this committee imposed in this bill is, should we include this class of people charged with a misdemeanor among a class from whom we will take a swab in the event of a conviction for that misdemeanor? So I'm on the fence. I don't feel that we've got enough good data to make that leap, that the majority of other states that take swabs, it's limited to felonies. And so when we go into this arena now of misdemeanors, even in the face of arguments, well, we will make some matches. But as raised by the opposition, we see people facing prosecution for false matches. There's no guarantee in this bill that that won't happen either. So it's not the panacea necessarily that we're hearing, that it's gonna, you open this pathway and it's gonna lead to multiple good convictions of bad people, which everyone on this committee wants to be supportive of. But we're put in a different position. We're put in the position of balancing protected constitutional rights, protected rights under existing law. That's why there's a bill here today, because existing law and the law passed by voters does not allow for taking DNA evidence for this class of misdemeanors or for any other misdemeanor. So I'm sorry, I know there are some specified that involve sexual crimes from which but there's a correlation there that has been legislated and determined. So I'm curious to hear others on the panel. I know that's been more of a statement than a question, but maybe in the fairness to the author, I would invite just your responses to some of the concerns I've raised.
Thank you, Senator. And I agree with you that it is trying to find the right balance. And I think that the unfortunate part of the discussion, there's a couple of elements of the discussion today that are unfortunate. One of them is it's surrounding the adoption of a proposition, which I think is gets in the way of looking at the issue itself and trying to understand if whether we can strike the right balance by taking DNA from what is now a misdemeanor conviction and help us solve serious crime. And I'm not trying to refight the proposition. I think it's in the atmosphere and it's hard to avoid. But I don't think that's the essence of what I'm trying to do here. I think what we have here is and the question was asked by my articulate opponent on my left, and that's, why is today different than what it was last year? And it's clear that it's different because we have some real data that we didn't have last year. And we now know that of those 9 crimes that had been decriminalized, that they contributed to the arrests of almost 200 rapists in the last 3 years and over 50 murders. And my articulate opponent raises the question of the convictions. How many led to a conviction? Well, as many know, our criminal justice system moves slowly, and that type of information would certainly be valuable, and it will come over time. We did our own research, and the others are welcome to do the same, to go back further than 3 years, and to maybe be able to look at that and determine how many convictions. But 200 arrests for rapes is a pretty significant thing, and 50 arrests for murder is pretty significant. And would they have been solved? So another one of the issues that were raised was would they have been solved without the DNA evidence? And it's the same point that I just answered a moment ago. Another was the high number of property crimes, and I've not focused on property crimes. Yeah, there was over 1,300 in total, but I focused on the serious rape and murder arrests that had been made. It was asked whether or not these folks would would we have been able to find them? Was there a qualifying offense difference than these 9 that we have reclassified? And the information I get from the Attorney General is no. These were all the reclassified crimes that led to that. That's the data. That's the data that was put in the database. The DNA database was from those arrests for those reclassified crimes. It wasn't for anything more serious than that list of 9, okay? Than that list of 9. Finally, concerns about the privacy of the DNA database, those are serious concerns. I take them very seriously, as we all should. And if there's abuse of the privacy of the DNA database, we should all look at that very carefully and see what can be done to have that not happen ever again. There's no ironclad where there is no database that hasn't been broken into by someone, but we should all take that seriously in how we handle it. And finally, Senator, you raised the issue of false matches, and those are also serious issues, irrespective of this bill. If that is going on, if there's things we can do to avoid it, no one wants that to happen. That's part of what we expect out of our criminal justice system. But let me say this, that I do think of the 9 crimes that we're talking about, there are a few that stand out as being more indicative of a more serious crime. And I do think if it's the will of the committee and the chair to look for compromises, I think they can be found in trying to plug the hole of this data gap with just, I think 3 of those 9 crimes, I think would go a long ways to try and resolve the problem that has come about. And I think that I'd be open to putting those 3 crimes in and eliminating the other 6 for at least the sake of progress in trying to make sure that we're not letting rapists and murderers slip through the cracks.
Okay, thank you. I am going to have to go, unfortunately, and vote in elections in just a minute. So I
Go
think,
right ahead.
Go right
I'll
ahead.
speak after you.
Okay, you know, because I have really been wrestling with this. I've spoken to Senator Glazer and to many of my colleagues and others about this. Part of me feels like DNA is relatively non-intrusive and relatively reliable. In asking, so I thought, well, you know, take DNA from everybody. That way we find just about everything that goes wrong in the world. But then as I started asking questions about that, it's, yeah, what does a hit mean in terms of multiple crimes, multiple people, actual convictions? What does the data tell us or not tell us? And there is the case that was cited in the analysis about the unfortunate other situation where a paramedic actually transferred data from one crime scene to another, and a man who was absolutely innocent was kept in jail and could have been tried life imprisonment or even death as a result of that. So I think we need, so then I began looking at the crimes, because unfortunately, the crimes, and I understand why that Senator Glazer ran, were the ones that were in the bill last year, which were Prop 47. And realizing that there are in fact other crimes that are wobblers, and I can see why the proponents of Prop 47 chose the crimes they did. They're relatively minor crimes compared to misdemeanor battery, sexual battery, assault with a stun gun, assault with a deadly weapon, domestic violence. And it seems to me that if we wanted to have a better understanding of DNA before we rush or we move to just do the Prop 47 issues, those 6 misdemeanors, which were not in Prop 47 because they were deemed too serious, wobblers, because they're all wobblers here, would have been a better choice. Now, last week, we reported out a bill from Senator Glazer that would try to refine the information that we get from the DNA base so that we would be better able to evaluate how we might want to expand it. I supported that bill. I could support, although I'm very reluctant to do anything, putting in these other misdemeanors that are more on their surface, more violent because they had more to do with bodily injury, and have reporting back from Senator Glazer's other bill to get better data from DNA. I would probably want them double joined, but I don't feel, I'm not comfortable doing the Prop 47 misdemeanor wobblers, and I'm not comfortable for many reasons. Not only because of what they are, but because the ones apparently that gave the most hits are the drug ones. And we are moving in a different direction right now, and I think it muddies the water to just choose them. So there may be, I think there's room for work going forward. Unfortunately, I don't see the time to do it now. And I think, honestly, the confounding it with Prop 47 is a problem. Because I want to say that I have a young staff member. She is Hispanic. She speaks with a heavy Hispanic accent, and she was told when her car was broken into that because of Prop 47, the police would not come and make a report because it would probably be a misdemeanor, and they can't prosecute for misdemeanors anymore. When last time I looked, that could be up to a year in jail, and you could prosecute. So there's a lot of talking we need to do to really think about the role that DNA is going to play. in our decision-making. I'm just not comfortable with this bill at this time. So I'll go vote in elections, sorry.
Well, Acting Chair. Acting Chair Leno, may I respond?
Of course you may. Go right ahead.
First, I appreciate the chair's earnest conversation that we have had together, and certainly the staff for trying to figure a pathway through. I would be supportive of adding those wobblers in, per the chair's suggestion. So if she would like to see those included, the challenge with it is that, we don't have the same data that we have for these other crimes. We don't know what they would lead to or not lead to. But I also find that the swab and the insertion of DNA upon conviction of these other crimes to be something I wouldn't object to, and if that's the will of the body, I'm happy to go in that direction. And finally, that
Of adding these additional
yeah,
to
I
your
think,
existing list, just
yes.
so I get clarity.
Well, as it may evolve, if we're going to amend it down, as I indicated, I'd be supportive of reducing the 9 offenses to 3, if that met the committee's interest, and then adding on the chair's.
Have you already stated which 3?
I have not, and I'd be happy to go through that and explain why.
Okay.
So if you'd like me to, of the 9, the 3 that seem to connect the most to future criminal activity, certainly in the area of murder and rapes, were possession of a controlled substance. That's Health and Safety Code 11377A. In the last 3 years, that arrests for those crimes led to 73 rape arrests and 27 murder arrests in the last 3 years. So I would put that one first on my list. The second one that I would put on my list would be possession of a narcotic controlled substance at the Health and Safety Code Section 11350A. Arrests for that crime in the last 3 years led to 61 rape arrests and 19 murder arrests. And the third that I would put on the list in order would be possession of a concentrated cannabis, Health and Safety Code Section 11357A. Arrests for that crime in the last 3 years led to the arrests of 17 rapists and 2 murderers. And so those are 3 of the 9 that seem to have the strongest connection to future bad behavior, as we would say. So,
Thank you, Senator Glazer. I'm just taking a few brief notes here. Give me one moment.
and accordingly, I would give up the petty theft with the prior conviction, the receiving stolen property. I would, we wouldn't advance the grand theft arrests and convictions, the insufficient funds for a check convictions, the shoplifting would be eliminated, and forgery would be eliminated.
Okay, I've got that. So just before we do take our vote, if in fact you're interested in doing that, much of what I'm about to say probably is not news to you because we have had very comprehensive conversations on this, but
I mean, I haven't been convincing, Senator.
for the sake of the committee, I just want, and I'll try not to repeat all the very articulate points that I think both Senator Monning and Senator Hancock have already made. But what resonates for me is there was one comment by our colleague that voters were duped by Prop 47. I am very shy to ever suggest that voters are duped. Even when voters passed Proposition 8, which I thought was a serious mistake and a constitutional error on the part of voters, subsequently ratified by the U.S. Supreme Court, I never thought they were duped. And so I don't believe at all that voters were duped relative to even the specific of DNA gathering with regard to these crimes. We had a full campaign. Opposition had every opportunity to make its points. Sometimes it made this point, sometimes it didn't. Voters didn't buy it. So I have a reluctance to speak over the voters in this case or in any other case. And I think, as Senator Hancock touched on, and I'm not here to say I'm totally opposed to expanding the collection of DNA in a very thoughtful and narrow fashion. I've not in past years, supported expanding it to misdemeanors. But through conversations with you, so you have been compelling, it has opened my thinking, and so I'm prepared to look at some possibilities here. Again, I'm not interested in telling voters they were duped and that.
I never said that.
I
Did you
know,
hear that
I know,
from me?
I know you did not. One of our committee members did, and that I'm not here to revisit any of the crimes in Prop 47. Voters have spoken, from my opinion. But with the expansion of more and more DNA gathering, I think we become ever more numb to the serious fact of what DNA collection is. And as was already stated by the opposition, this is very important information. This is all about personal privacy written into our state constitution. It's not just a mere swab of the inner cheek that takes just a second. It is far more than that, and we become desensitized the more and more we expand it. And so as we consider that, I think we are suggesting to our constituents a false sense of security. Just collect more DNA, and we'll all be that much safer. When we aren't even testing rape kits, we've got the DNA. Rape. They sit for years and years, and we're told by local law enforcement they don't have enough money. We give some more money, they still don't. There's never enough money. But then why are we going to collect, which is a real infringement of privacy? And as Mr. Baca said, what is the compelling government reason? So for all those reasons and others that my colleagues have already stated and relative to our conversations earlier, though I am prepared to earnestly continue our conversation and look at some of the misdemeanors and wobblers that the committee has suggested that I think could have a real correlation. And data is data. As Ms. Minsker had pointed out, any number of concerns and additional questions that the data, not to say it's not accurate, but it raises additional questions. I'm so glad you brought forward your other bills so that we can better collect that data and know more about DNA collection. So for those reasons, I won't be supporting the bill today. But if you're certainly welcome to close. I think we'll just leave it at that for now, and I know we have a motion by Senator Stone.
Opportunity to close,
Of course,
Senator.
of course.
I appreciated the well-meaning comments, and look, I'm not here to fight the big picture of privacy. I mean, we give a driver's license, we have a fingerprint, we have a social security number. It's a good conversation to have, right? But it's not what I'm trying to fight here. I'm just trying to find bad guys who have committed serious crimes, and that we have the power today to try to capture them with very little inconvenience and impact on people's privacy. And I think it's done in the context of, yes, there's more, we could look at this more comprehensively, and I support that, and we've had that conversation. But I think that we're missing an opportunity here to try to take some controversy around Prop 47 and show that where we see that it has some shortfalls, we're willing to fix it and get it right. Because I think that one of the challenges for those who support Prop 47 is that you're going to have, what you don't want to have is swings. You go back and forth where we get tough and then we get soft. Then we get tough and then we get soft. And we know that in the long run that that's not a healthy way to run a criminal justice system. And I think that where we have made these changes within Prop 47, I think the challenge for us, if you want to have support and sustainability for that type of reform, is to make sure that where we have some shortcomings, we fix them. And I think that's my biggest disappointment in working on this issue, is that we spent over an hour talking about statute of limitations for rape going beyond 10 years. And yet, that change would lead to how many more convictions? Nobody knows. Nobody has any clue. Yet, with this type of data, we know 196 rapists would not have been caught. Okay, I mean, you could have said we could have found them in other ways, but my big disappointment is that I think if you want 47 to be sustainable, it's to see where there are shortcomings and to fix them, and this is the opportunity to do that. I think it's not with 9 classifications of crimes, you can do it with 3 and go 85% of the way, and I'll be disappointed that if the committee can't find a way to do that, that I think it's going to lead to an erosion of something that many members of the committee want, which is a more sustainable criminal justice policy that has the right balance. And I think that will be my disappointment if the committee goes in the direction it seems to be going. But thank you for that opportunity and
Of
for
course,
the
Senator,
conversation.
Thank you. And I think the one thing that we all have in common here is trying to find that appropriate balance. That's part of this fascinating, if sometimes crazy process that we have of all of us individually and then subsequently collectively trying to identify what that balance is. And I just want to throw into the mix of tough and soft as we can also get smart. So, Madam Chair, we have the authors close and we have a motion.
It was due pass to appropriations.
That was the motion. Mhm.
Yes, please.
Hancock?
No.
Hancock, no. Anderson? Glazer?
Aye.
Glazer, aye. Leno?
No.
Leno, no. Lou? No. Lou, no. Monning?
No.
Monning, no. Stone? Stone, aye.
Thank you all.
Thank you.
I have a witness from Southern California who has to catch a flight at 4. Laura said I could go ahead of him, but I was here also. I don't know his situation.
Okay, who